How do I set up an irrevocable trust? If you are considering setting up an irrevocable trust, you might be wondering what steps you need to take. This process involves several important actions that can help with estate tax planning. Let's break it down in simple terms. First, you need to understand what an irrevocable trust is. This is a legal arrangement where you, the grantor, transfer assets into the trust and give up control over those assets permanently. Unlike a revocable trust, you cannot change or cancel this trust once it is established. This type of trust is often used for estate tax planning because the assets in it are usually removed from your taxable estate. Next, you will want to choose the type of irrevocable trust that fits your needs. There are several types, such as grantor trusts, intentionally defective grantor trusts, spousal lifetime access trusts, and qualified personal residence trusts. Each type has different tax implications and rules about how income and distributions are handled. It is wise to consult with professional advisors before setting up the trust. An estate planning attorney can help draft the trust document, which outlines the terms, beneficiaries, and trustee powers. A certified public accountant can assist with tax planning and help you obtain a tax identification number for the trust. Speaking of tax identification numbers, you will need to get one for your irrevocable trust. This number is separate from your Social Security number and is necessary for tax reporting and opening bank accounts in the trust's name. Choosing a trustee is another important step. The trustee is responsible for managing the trust assets according to the trust terms. This could be an individual or a financial institution like a bank or credit union. They will hold legal title to the assets and manage distributions. Once you have a trustee, you will need to open bank accounts in the name of the trust. Financial institutions will require documentation like the trust agreement, tax identification number, and identification of the trustee. Remember, the grantor does not control these accounts, the trustee does. Next, you must fund the trust. This means transferring assets from your name to the trust's name. For bank accounts, you will need to close or retitle personal accounts and transfer funds into the trust's accounts. If you do not transfer certain assets, they will remain as part of your estate, which can affect your estate tax planning goals. Maintaining a clear separation of trust assets is essential. Trust assets should not be mixed with the trustee's personal or business assets. This separation is important for legal protection and proper accounting. Understanding the tax implications is also vital. Depending on the type of trust, the income generated may be taxed to you, the trust, or the beneficiaries. The trustee should work with a certified public accountant to file the necessary tax returns. Finally, consider the jurisdiction where you set up the trust. The state laws can impact how the trust is managed, its tax treatment, and protections against creditors. This choice should align with your long-term goals. In summary, setting up an irrevocable trust involves understanding its purpose, choosing the right type, consulting professionals, obtaining a tax identification number, selecting a trustee, opening bank accounts, funding the trust, maintaining asset separation, understanding tax implications, and choosing a favorable jurisdiction. Each step is important for effective estate tax planning and ensuring that your wishes are carried out.